Today is Wednesday, July 10th. Calling this session, this meeting into session. This is the Wayne County Ethics Board. It's Wednesday, July 10th, a little after 9 o'clock. Calling this meeting into session. We go through our agenda here. Excuse me. We're going to start a roll call.
Robert Young.
Here.
Freeman Hendricks.
Here.
Mona Hamoud has asked for an excuse. Sue Carnell.
Here.
Sandra Bucero.
Here.
Edward McCall Thomas.
Here.
Karan Pinkins.
Present.
You have a quorum present.
Thank you for that. All right, moving on to the next item of our agenda, we're at item number B, the approval of the minutes of the June 19, 2019 meeting. Has everyone had an opportunity to take a look at those minutes, and has everyone received a copy of them?
Yes.
And is there a motion to adopt or accept the meeting minutes from the June 19th meeting?
So moved. Second.
All in favor?
Aye.
So moved. All right, moving on to the next order of business, item number C, which is unfinished business. Number one on the agenda is continuation from June 19, 2019 of the hearing on the complaint by County Executive Warren C. Evans against County Treasurer Eric Sabree. I believe Mr. Sabree and his attorney is present. Am I correct? All right, sir, I think we can pick up where we left off on June 19th. I believe you were going to make a closing argument, if I'm not mistaken.
That's correct. Thank you. I want to begin by letting you know that my client...
I'm sorry. Excuse me. Hold on. Turn your microphone on first. And also, before we get started, I just want to make sure everyone, if they can, silence your phones, please. Also, just out of respect and courtesy, can everyone make sure, if you're going to have a conversation, please exit the room. No side conversations. Again, make sure your phones are silenced. This meeting is being recorded, so we just want to make sure what we're picking up is what's being discussed at this table here. Thank you so much. Go ahead. Proceed, sir.
I want to thank the board for the opportunity to be here. I will inform the board at this time that my client, Mr. Sabree, has to leave at 10:15 for a close friend's funeral. I will be staying and I will be available until the conclusion of the proceeding. With that, I'd like to begin my argument. Hearkening back to the first hearing that was held in this matter, a hearing at which just procedural matters were discussed, it was April 3rd, 2019. And in listening to the tape of that proceeding, one thing struck me, and that was from that hearing on, there was discussion regarding what would happen if the complainant, Mr. Evans, did not participate in this proceeding. And there was some discussion and questions were asked regarding whether the board had ever proceeded in an ethics board hearing without the complainant present, and your counsel indicated that he couldn't speak for all time, for all history, but during the time that he's been representing you and providing legal advice to you, you've never proceeded without a complainant present. That was April the 3rd. Nothing changed. That's really, to a large extent, how the hearing began on May 15th, with me complaining about that and asking for a dismissal for assorted reasons, including the fact that the complainant was not here, not available for cross-examination, had not participated. According to the Ethics Code, Section 40-7, which provides my client his due process rights, the burden of proof in this matter is on the complainant, Mr. Evans, who filed the complaint. I also complained at the time that I filed my answer that I felt that the answer was deficient, and I laid out the reasons why it was deficient. First of all, I indicated that Mr. Evans very clearly indicated he had no personal knowledge of the facts. He relied on two hearsay pieces of evidence. The hearsay pieces of evidence are a Detroit News article and a Detroit Free Press article. I believe one is dated February 12, 2019, and the other was dated maybe the 12th, but updated on February the 13th. So what happened was we had those two articles. They were appended to his complaint. Actually, at the time I filed my answer, I was unaware that he had even included a sheet that specified some type of conflict of interest violations, and I learned about that later. But I complained and I said, look, I'm preserving these issues as affirmative defenses, and none of those arguments that I made In the answer, none of the arguments that I made when I moved for dismissal on May 15th have ever truly been addressed. My motion was dismissed without prejudice. I'm not certain what that means in a proceeding like this. But I'm here today to essentially renew that motion. I'm renewing my motion to dismiss based upon all the grounds that I've set forth before you. The first thing that I want to point out about the newspaper articles is the newspaper articles that were relied on by Mr. Evans. If you take a look at them, if you have an opportunity, looking at the Detroit News article, the one that was updated on February 13, 2019, the experts that were interviewed by the Detroit News for that article said that they did not see an ethical violation. They interviewed a law professor, and then they say experts, and they don't name who all of them were, but they say including Peter Henning, said that he saw no ethical violations regarding those 2011 purchases. So you have Mr. Evans relying on a newspaper article that really doesn't implicate any type of conflict of interest. Now, the Detroit Free Press article that he referenced in his one-paragraph letter, his cover letter for his complaint, stated as follows, quoting another professor from Wayne State University Law School, John Moak. He said, for a counter-treasurer to be trading in tax auction properties has the appearance of a conflict of interest and could possibly be trading on inside information. What's interesting about that, what has always stuck in my mind since I read that, is he said an appearance of conflict of interest. I'm not sure that I understand what that even means. I want you to know, a substantial portion of my law practice involves the representation of lawyers before the state's disciplinary agency, the Attorney Grievance Commission. I also represent quite a few judges. Under Michigan law, an attorney acting as an attorney in a court proceeding or in the course of his or her representation of a client can't be found guilty of an appearance of a conflict of interest. There has to be a conflict of interest. So I don't really understand that. There is an appearance of impropriety standard that lawyers must adhere to, but not in dealing with conflict of interest. So it has been my position, and it is my position, that the complaint that was filed in this matter is deficient. If there was any doubt that Mr. Evans had no personal knowledge of the allegations that he was raising, he clarified that in a letter that he sent you on May the 9th. He sent the board a letter, and in that letter he said, I have no personal knowledge about this. I'm not going to come and testify, because if I did, I couldn't testify to anything. That's a paraphrase of what he said. You got the letter, and I got it, I think, the day before the last hearing. So the complaint was deficient, and the board made a determination, apparently, that they were going to proceed. I think that was tremendously unfair to my client. I believe it was a violation of his due process rights that are provided in the ethics code itself. So here we are. The decision was made that we're going to proceed. Now, where are we at? What has the board looked into over the course of two hearings, May the 15th and June the 19th? Where are we at in terms of the evidence that you've seen regarding conflict of interest? Here's what you know conclusively. 71 counties in the state of Michigan, 71 counties in the state of Michigan, and the state of Michigan itself allow treasurers and employees of the treasurer's office to partake in county auctions. 71 counties. You heard testimony from Marty Spalding, whose company handles the auctions for the state of Michigan in 67 of those counties. And there's something I want to stress about the 71 counties. I never, after I filed the answer, had the opportunity or the resources available to me to go out and check to see what the other 11 or 12 counties do. I never did. But at the May 15th hearing, a board member asked Mr. Spalding, the question was raised to him, do you know of any county that has a prohibition, other than Wayne County, do you know of any county that has a prohibition against a county treasurer or his or her family members taking part in the auctions? He said, no, I don't. He doesn't know that. The restrictions that his company imposes are the restrictions that are mandated by Michigan statute. And those are, the person can't have any blight tickets pending against him or her, and they can't owe taxes. So that's where we're at on that. But there were other means that I used to point out that there was no conflict of interest. I submitted evidence to you concerning an April 2014 email exchange between Ms. Cynthia Yoon, who at the time was working in the Corp Counsel office, and the then Chief Deputy Treasurer of the Wayne County Treasurer's Office, David Szymanski. And there was discussion in there regarding what the rule required in 2014. And there was some going back and forth, and I gave you the emails. And in the going back and forth, what was said was this: the rule does prohibit the treasurer or family members from taking part in the county forfeiture auction. That was clear. She made that clear. But the most important aspect, her concluding email to Mr. Szymanski stated as follows: at a minimum, it looks bad. There was no discussion between him and her, Mr. Szymanski and Ms. Yoon, regarding a conflict of interest. And I can tell you this, that, in my opinion, is very, very strong evidence that nobody ever discussed this rising to a level of a conflict of interest. Look, the county treasurer's office has a lot of rules and regulations that govern everybody there, including Mr. Sabri. I've learned since representing him in this proceeding that there's a dress code. I would have never known that. Being a member of the public who lives in Wayne County, who pays taxes, they have a dress code. They have a rule against county employees using county computers for personal business, paying bills, purchasing things along those lines. The rule that was in existence prior to 2015 and that came back into existence after 2016 was a rule, an internal rule, that told employees you can't do this. It's not a conflict of interest rule. And please don't let anybody tell you that. Once I obtained that sheet that was missing, the sheet that Mr. Evans provided apparently to the board with his original filing, it had 5 different categories of conflicts of interest. And at the June 19th hearing, I went through them with my client. They talked about procurement, the county procuring things from a company where a family member or an employee has an interest, and talked about education, talked about a lot of things. But you know what? I didn't need to point out to you that there were deficiencies in that complaint. It wasn't just me that needed to point that out to you. Because when you had your counsel, Mr. Williams, prepare the list of things that you wanted from me and that you wanted from Mr. Evans, when he prepared that list, he asked Mr. Evans to specify the rule violations within the ethics code that he felt were violated. I have to believe that that was done at the board's suggestion, or at a minimum, done by your counsel. You also asked that he be present at the hearing. You also asked that. I have to believe that you felt that his participation was important, that it was needed in order for you to proceed. I have to believe that because you asked for those things. Why we ended up proceeding on May 15th, I'm at a loss for. But I am telling you very seriously, my client and I believe that the due process rights that are provided for him as a person defending this action have been violated. The only evidence that you've seen in this matter is evidence that has been provided by my client. The only testimony that you've heard has come from my client. I did submit a letter from Melanie Kersey, the Chief Deputy of the Wayne County Treasurer's Office. I hope, for heaven's sakes, you're going to consider that. I also submitted a letter from Maureen Taylor. Now, Maureen Taylor was actually here at the hearing on May 15th, but she couldn't come back on May 19th. So I put the one witness that I was allotted time for on the stand, that was Marty Spalding. And what Ms. Taylor did is, aside from submitting the letter, she stood up and addressed the board during public comment. So I would hope that you're going to consider those 2 letters. it's important to us that you consider those letters and you consider what he's done during his time as county treasurer. You've heard him testify that foreclosures are down by 85%. That's been his goal. That's been his primary objective. Now, rule changes. We've discussed at some length over both of the hearing dates, May 15th and June 19th. We've discussed the fact that the rules were changed in 2015 and 2016 to specifically allow family members of the county treasurer and employees of the county treasurer's family members to participate in the auction. That's the strongest proof I have here today. If you were to tell me, Thomas, we want to know what your strongest argument is that there was no conflict of interest, I would say, well, aside from the fact that the state of Michigan and 71 other counties don't have this type of prohibition, the then county treasurer, Mr. Wojtowicz, I hope I pronounced that name correctly, he changed the rules in 2015 and 2016 to allow family members of employees and the treasurer to participate in the auction. What we don't know, and what we could never tell you, we just don't have the resources to do it, we don't know how many employees of the treasurer's office might have purchased property at those auctions. What we do know is that my client, Mr. Sabri, and his family didn't purchase any, but we don't know who else might have purchased that. Then back in 2017, 2018, you heard testimony that the rules were changed again. My client said he didn't know how it was changed, but it was changed to prohibit the treasurer and his or her employees and their family members from participating in auctions conducted by the treasurer's office, not conducted by an independent treasurer. So we have to step back in time now. Why do I feel that all of this is important to my closing argument and 2 days of testimony? 2 days of testimony. Well, my client was a new employee at the treasurer's office. He was hired on in 2011, I believe April of 2011. Comes on staff there, and there's an auction, and his wife purchased 3 pieces of property in Harper Woods, which is in Oakland County, which is in Wayne County. I apologize. She purchased those from the auction. He said he felt at the time that she did that since the auction was not being conducted by the county treasurer's office, that she could do it. He said that, and he acknowledged in our answer going back to March. He acknowledged if he could change things, he looks upon that as a mistake now, and he wishes he could undo it. Hindsight's always 20/20. But you know, one of the most unfair aspects of the inquiry here into those 3 Harper Woods purchases in 2011 is the fact that the ethics code that created this body, that gave life to this body, it wasn't adopted until April of 2012, and it didn't become effective for another 60 days. Look, being a lawyer that represents a lot of professionals and elected officials, I can tell you, we always look at rules and rule changes to see when they're adopted and when the effective date was. Those are jurisdictional. One of the board members, as I was listening to the tape of the June 19th hearing, one of the board members referred to our argument that 2012 ethics code didn't apply to those purchases. He referred to it as a compelling argument. I agree with that. It is a compelling argument. It's one heck of an argument. There is absolutely no way in the United States of America in 2019 that people can apply laws retroactively. It just doesn't happen. And if it is going to if that was going to be done,
Mr. Thomas,
there would have
one quick second. Sorry to interrupt you. Ma'am, can you turn off the light on your phone there? It's sort of distracting. No, it's okay. Okay, you can continue.
Thank you. The point that I wanted to make was, if a statute or ordinance is going to somehow be made retroactive, there has to be a very, very clear intent within there, and that has to be capable of withstanding court challenges. Because let me tell you, the legal system looks unfavorably on ex post facto laws. So I'm not saying that it can't be done, because actually it was done in Michigan some time ago with the drunk driving laws when they created stackable offenses. But not to get sidetracked on that, the significance of the 2012 Ethics Code is that it was adopted in April and it became effective 60 days later. And that type of lag in time is always provided as a notice period for the world to know this was adopted and this is becoming effective. So those are the reasons that we believe we have proved to you, really, beyond any doubt. And you have to remember, I don't want to keep saying it because I don't want to sound like a broken record. We don't have the burden of proof. We don't have any burden of proof. The person that filed the complaint has the burden of proof. He didn't provide any evidence. We provided the evidence. My client's testimony on all points has been uncontested. You haven't heard testimony from anybody else that contested any fact that he testified to. So where are we at today? Where are we at today regarding this complaint? And why do my client and I feel that his due process rights have been violated and that we've been treated unfairly? The fact of the matter is, I don't believe that this proceeding should have ever gone forward on May the 15th. That was my position at the time. That's my position today. But you as a board have the ability to rectify that. And I will tell you this. I believe that fairness and application of the rules and a strict interpretation of the evidence, a review of everything that's been submitted to you, a review of the fact that no witness list or evidence list was filed by the other side, the fact that he never showed up, the complainant never showed up. When you look at all the facts and circumstances, I believe that you're going to find that we bore the burden of proof, and we proved that my client didn't do anything wrong. He came here before you 2 days he testified. May 15th and June 19th he testified. Answered all of your questions. We attempted to provide all documents that were requested from us that we could readily obtain. I believe the tally on the documents that we submitted to you, it was well over 2,000 pages. One of the exhibits alone that you requested was somewhere in the area of 1,744 pages, and there were several hundred other pages that we submitted to you. We've stood ready at every reasonable time that anything was requested of us. We stood ready to provide it. The last hearing, June 19th, we had to draw a line. We're not going to come back again for questioning, and this proceeding has to end sometime. I think if it doesn't end today, it's got to end sometime within the next few days, because 150 days would be up. But we're confident that if you give a fair review to all of the evidence, and all of the evidence that you should have had before you, testimony from the complainant, review of any records that he might have. When you review the fact that the only party that has been financially inconvenienced by this proceeding is my client. My client had to pay for his own fees. The chairperson at one of the prior proceedings referenced something about him going to Corp Counsel for representation. I told the chairperson he did that, and he was told, you can't do it. You've got to retain your own counsel. This has posed a tremendous burden for my client, financially, time-wise, and it's put a burden on his staff. I will tell you this. He's got over 90 employees working at the county treasurer's office. I think that any of you would recognize that in an office that size, employees talk, they feel pressure put on them as a result of this. Some of them may be unhappy with their employment. Some may be unhappy with their pay grade. People complain. It's put a strain on my client and his office. And why? I believe that the reason that we're here is because there were some negative newspaper articles that were published. And I believe that a lot of that results from the fact that my client, Mr. Sabri, oversees an area of county business forfeiture of property from individuals, for the most part, who are economically underprivileged, and that's why they're unable to pay their taxes. And that presents an issue that hits people in the gut emotionally. But I have to tell you, I don't believe that this board ever had the ability, the legal ability, under the rules that you're enforcing, to proceed with this matter. I just don't. The fact that a couple negative newspaper articles were published, there are lawyers on this board, and I will tell you, you know that newspaper articles could not be introduced in any criminal proceeding or any civil proceeding as substantive evidence. Just not doable. So why did we do it here? I'm asking you, this is what I'm asking of the board. I'm asking you to think about the questions that I've raised here today. Think about why we're here today and what has been accomplished and what has not been accomplished. Think about who participated, who didn't participate. Think about the fact that my client's testimony is uncontradicted on every point. Every point. I wish that at the May 15th hearing I had had the opportunity to call one or two of the other witnesses that I had present that day. They might have added some, I believe they would have added something to shed some light on the facts in this matter. But even the way the hearing was conducted on those dates, the way it was truncated and what have you, the way it was truncated on June the 19th, I had a brief closing argument to make and it had to be put over until today. I realize that all of you have time schedules and all of that, but see, I don't necessarily look at things from the world's perspective. I look at things from my client's perspective. He had to, retain me to come back here today, pay for my services. Those are hardships that he's suffered. He's the only witness you've heard from, and we're asking for a decision in our favor. First of all, I don't think you've heard any evidence of a conflict of interest. I really do not believe that you have the ability to look at those 2011 purchases that Mrs. Sabri, his wife, made. I really don't. I believe that. I believe that would be some type of ex post facto examination of the conduct, and I just don't believe you have the right to do that. And I think that the board was very concerned about whether there were other purchases. I listened to the tape of the May 15th hearing and the June 19th hearing, and I will tell you, according to my count, and I'll stand corrected, I believe that my client was asked no fewer than 10 times whether his wife or her company made any purchases of properties from the tax auctions after the 2011 purchases. And his answer was no. And you haven't seen any evidence to contradict that. Those were isolated incidents. His wife felt like she wanted to dabble in real estate, try to develop a little business. That's what it was. That's what it was. So I think that we're asking you to review the totality of the evidence that has been submitted to you, consider who submitted it to you and who participated in this proceeding and who didn't. And I think that when you do that, you're going to return a finding in our favor, no conflict of interest, and that my client hasn't done anything unethical. Now, there is that 2017 purchase that my client's son made at the behest of a client. And a board member, Judge Thomas, asked a question that day. He said, well, you know what, and I'm paraphrasing, what I'm wondering is this, Mr. Thomas, would Mr. Sabri's son, who's an attorney, who's acting at the behest of a client, even have been able to ethically disclose to his father, hey, this is what I'm doing in my practice and this is who I'm doing it for? And the answer was no. You know that. Any lawyer on this board knows that. You can't do it. Be protected by the attorney-client privilege. But you want to know what's even more important than that? What Mr. Spaulding said when he was testifying about why he doesn't believe that there should be any prohibition, he said not only on the county treasurer or employees or family members, he said on people who do contract work for the county. He said the reason that he believes there should be no limitations like that is because the goal of the auctions are to get the most money for a piece of property that you can possibly get. That's the goal of the auction. And the state of Michigan accepts it. 71 other counties accept it. We don't believe that my client is entertaining making any changes at this time, but he certainly has the right to, just as Mr. Wojtowicz did back in 2015 and 2016. So I want to end where I began. I want to thank you for the opportunity to appear here today. I want to thank you for the courtesies that have been showed to us during the course of the proceeding. And as I indicated, my client has to leave at about 10:15, but I'll be here for the duration. Thank you.
Okay. All right. At this time, I'm going to ask if there's any questions from any of the board members with respect to Mr. Thomas or Mr. Sabri, and if there's any sort of follow-up or opinion from Mr. Williams with respect to Mr. Williams. You've attended, you've followed these proceedings. You've just heard Mr. Thomas's closing arguments and the arguments that were raised. At this time, do you have any opinions or for this board that you would like to express?
Question to me.
Yes, sir.
Well, the first opinion is obviously, as the lawyer, I don't necessarily have a vote on what the board does do. When we started this process, I gave the board my view that the burden of proof has always been defined to entertain two concepts: the burden of going forward and then the burden of persuasion. The burden of going forward is simply to present the complaint. Mr. Evans did do that. The board discussed this at some length before proceeding, that there was the Apex rule, particularly as to executive employees, that suggested that perhaps we couldn't expect the county executive to show up in these proceedings and present evidence. He provided his proofs. He then provided the letter that he provided. So he did meet, at least in my opinion, the process of going forward. Now, whether this board has been persuaded by all that it has received in terms of evidence and solicitation of documents, that is ultimately a question for the board. I mean, you have in front of you, again, a request to dismiss, which jurisdictionally, under the language of the ordinance, that's one of your options. You can dismiss on the face of the complaint. You can dismiss because there was insufficient evidence in the complaint as an option. But you also have the option of looking at the evidence you received and making a decision as to whether you think there was an ethics violation. When you look at the ordinance, and particularly the conflict of interest section, particularly section 40-4A1, it talks about a public servant shall not participate in the making of any county decision with respect to any matter in which they or a relative or domestic partner has a substantial financial interest, which is distinguishable from that of the general public. It didn't talk about merely this notion of buying property. It talked about an interest. One of the things that Dr. Carnell raised early on as a question is the completion of the disclosure form by the elected public officials and the disclosure of potential interest in businesses that might be doing business with the county and whether that disclosure had been made. We also have a substantial amount, or at least a number of instances in which not only was there a purchase of property, even after 2012, there were payment plans that were executed with the business that was owned by Mr. Sabri's wife. And that also has to be factored in as to whether that means anything to this board in evaluating whether there was a conflict of interest as defined by the ordinance and as prohibited under the standards of conduct. It's not for me to decide that. I only note that the inquiry, even under the rules and elsewhere in the ordinance, at points in time the rules contemplate the filing of an anonymous complaint raising a conflict of interest, which would be almost wholly inconsistent with the notion of the complainant coming forward and presenting evidence and proving a case. I can't answer why all of these things were written that way, why there are all of these inconsistencies. The bigger question here is, what is the role of this board in dealing with a complaint about potential conflicts of interest and the public view of how officials conduct themselves, and whether there is an independent role of this body to evaluate, and when a complaint is before it, whether there is a public perception of conflict of interest that has surfaced and can be evaluated by this board. And that's really the question that's before you, even beyond whether Mr. Evans, rightfully or wrongfully, didn't show up to prove the conflict of interest because he didn't have any facts, whether this board has some independent duty and obligation to evaluate the question of conflict of interest by public officials that work for the county. And I do disagree with the notion that this gets treated like a conflict of interest for a lawyer. The perception that the public has, and there has been a significant amount of public oversight even today of this process. The perception of a conflict of interest, I think, is what drove the adoption of the ordinance. And I think the import of the ordinance is to give the public at least some assurance that the county is endeavoring to evaluate and assess the potential conflict of interest situations that might arise that create an impression that the public is not being treated fairly, and that there are conflicts that might arise that suggest that someone is being treated differently than a member of the public at large. And that's sort of this overriding question that comes in here. I think the Ethics Board was right to proceed with its investigation. I think we've discussed ad nauseum the fact that you could independently request information and investigate. The ordinance contemplates that. I can't tell you how to resolve the conflict. We have discussed previously some of our suggested revisions that we're going to recommend to the commission. These may be other issues that we need to address to the commission, but the ordinance as written contemplates your right to an independent investigation.
Thank you for that, Mr. Williams. Yes, Mr. Thomas.
Can I say something?
Sure.
Chapter 40-7, E small f reads as follows, and I'm just going to read one sentence from it. The complainant shall have the burden of introducing the requisite evidence to prove the alleged unethical.
You need to turn on your mic, Mr.
Turn your mic.
Because it records it, I'm sorry.
Yeah. Is it on? Okay.
Yes.
Section 40-7E, small af, there's a bunch of small letters here, but I'm reading from page 16 of the Ethics Code at the bottom. It says that the standard of review shall be the preponderance of credible and relevant evidence. The complainant shall have the burden of introducing the requisite evidence to prove the alleged unethical conduct. That language couldn't be any clearer. It really couldn't. And whether changes are going to be made in the future, I would think that if you think that you may be going down this course again, that maybe some changes would be in order. But the Ethics Code is what the Ethics Code is today, not how it's going to be changed or what suggestions are going to be made to change it.
Well, let me just add this, because I have thought about this as well, and I've looked at it. I came to this board in 2014, and I had the pleasure of serving with the prior chair, Judge Jovan, right at the tail end of his tenure. And prior to me coming to this board in 2013, there was a complaint filed against then Sheriff Benny Napoleon. And they heard that complaint. There was no complainant before. I've watched the tapes. Anyone can go look at it. It's up on YouTube. There was no complainant before this board. This board voted, and they listened to it. One of the arguments that the attorney for Benny Napoleon made, Mark Brewer, was that they were not afforded enough time. They made their arguments. They ruled within 30 minutes. There was no complainant here. I watched the tape. There was no complainant. They found that he was in violation of using county property in his pursuit when he ran for mayor of the city of Detroit. He used county police cars. Now, again, there was no person here. There was no physical person here. There was no complainant here. They looked at the evidence that was presented that came up, the documents that they requested and sought out, and they made their decision. Again, the argument that Mr. Brewer made was that they were not afforded enough time. And I did hear you, and I think that when you said that you felt that you weren't treated fairly, we have exhausted the 120-day period with allowing you to come back and present further evidence. We've asked for other additional evidence. At the last hearing, it did come up. I know a board member raised the issue of some of the notices that went out, the payment plans that was never submitted to us. I did raise the fact that, and your client talked about it, of how these forfeiture notices are automatically generated after 2 years if the taxes are unpaid. And with that, he expressed how it happens. He said it's automatic. And I expressed, well, if these properties that were owned by his wife or his son's properties or whoever, which accrued some $50,000 in past taxes, then obviously those taxes had accrued over a number of years. So obviously, from his own testimony, forfeiture notices would have been generated. And I asked for those notices, and I was told flat out, we're not giving anything else. That's it. We've given 2,000 documents. And I did reference the letter that was sent out by Mr. Williams. And I stated it was very exhaustive. Actually, it was a 4-page letter. I thought it was 2, but I'm looking at it again. It was a 4-page letter. And if you look down at subsection W here, it says, please provide a list of properties that were foreclosable, but were not foreclosed on from 2014 to 2018. Again, that was never provided to us, and you told us you provided everything that you were going to provide in your 2,000-page document. Again, we did receive that right before our hearing on May 15th. Some of us had not received it. Some of us didn't have the opportunity to go through it thoroughly. But again, those are things that, personally, for me, I would have needed to make a conscious decision as to what took place. Again, I think I did mention my concern beyond his companies, his wife's companies. I'm looking at companies, the Woodward Development Company or the Woodward Group that seems like was purchasing properties that managing partner was Adam Sabree, Mr. Sabree's son. Beyond that, but my concern also has been, I know a lot of people in the county has had foreclosures filed against them. They've lost properties. They've seen the foreclosure notices and the forfeiture notices after 2 years come out to them. They've been assessed fees and fines and whatever else. And my concern is if his family members or his wife was purchasing these properties, were they getting the same treatment as the general public? And when you tell me that you're not going to provide me with forfeiture notices or these note payment plans that would have shown that they had entered into these payment plans, things that would have been helpful to your client, when you say that you're not going to provide it, it makes me think that those things just don't exist because they were not sent out to his family members. They were not foreclosure notices and forfeiture notices, possibly were not sent out to his wife's properties. I personally find it strangely uncredible that his wife was able to purchase these properties from the county without his knowledge. If she felt that the county treasury was not being run by him, she could purchase them. I'm sure there was some discussion. I can't buy a pair of shoes without my wife knowing about it. So if he's able to purchase homes and properties and all that, and he doesn't know about it, I find that strangely. It's incredulous. I can't believe that. I can't follow that sort of thinking. His wife, if they're currently together, unless they're divorced or estranged or something like that, if they're currently together, it's hard for me to believe that. With respect to what you mentioned with respect to the attorney-client privilege, I'm an attorney. We know how these things work. If I have a client and I feel that there might be a conflict, the attorney-client privilege only relates to if you talk about something and you don't have permission from your client to talk about it. So if I represented a prior client and I'm representing a new client, I can ask the new client for permission to talk to the old client to represent them. If the client gives me permission, yes, I can go talk to this person and say, look, I represented you before, this person here, is it okay? You can have those conversations. The attorney just has to initiate that. It would make sense if a person comes to me and my father is the treasurer and they want to do business with the treasurer's office, that I will first say to them, well, my dad is the treasurer. Is it okay if I go and talk about this to my dad just to make sure there's no conflict of interest? That would not violate the attorney-client privilege if the client gives you permission to go talk about it. Okay? That's my piece. Is there any
Might I
questions?
respond, Mr. Pinkins?
Sure, go for it.
Well, first of all, regarding the Benny Napoleon case, I want to be very candid with you. I know nothing about the facts of that case, so I'm not prepared to talk about it. I almost wish that had been brought up to me previously, since we've addressed that issue at 2 prior hearings, but it never was brought, excuse me.
Let me just finish. We did talk about there has been times, and I raised that at the first hearing, the May 15 hearing, there was a time when there was not a complainant before this body, but we brought it that it was initiated. A complaint was initiated. So go ahead.
My memory of that is not consistent with yours, but this is what I would say about the Benny Napoleon case. The way you phrased it here today is all I know about it. And you said something very critical. If I understood you correctly, you indicated that the attorneys didn't raise the issue that there wasn't a complainant. They were complaining that they didn't have adequate time to respond. I will tell you, I don't know why they didn't raise that issue, but just because they didn't raise that issue doesn't mean that it's not a viable issue to be raised. We have a very specific rule on point that talks about who bears the burden of proof. Now, there was something you said, and I will say this, Mr. Pinkins, your memory and my memory differ greatly regarding what Mr. Sabri testified to regarding the 2011 purchases. I sat here through both hearings. I prepared the answer for him. He never testified that he did not know that his wife was buying those properties, those Harper Woods properties in 2011. His testimony was that he felt that it was not a problem because the county treasurer was not conducting the auction. It was being conducted by an independent auctioneer. So your memory and my memory differs on that. And I got to tell you, I've listened to the tapes pretty recently, but if that's a key area for you and you believe that that's a key critical credibility issue that you want to explore, you may consider reviewing the tape, because I heard him testify no fewer than 2 or 3 times that he knew about it, but that he thought it wasn't a problem because an independent auction house was conducting the auction. Those are my comments.
Ms. Carnell.
Thank you, Mr. Thomas, for your comments. Thank you, Mr. Sabri, for being here today. I know you have to leave very shortly. Whether or not my colleagues believe that this should be dismissed, I just wanted to say a couple of things. The first one, I think we're on the edge of whether or not there's violation to the ethics code, particularly as it relates to 40-4, sections 1 through 5, because of the word substantial. What does substantial financial interest look like? Mr. Sabri did, in your letter, Mr. Thomas, admit to doing some wrongdoing. Mr. Sabri also admitted that he had a conversation with his family to correct all of this action, to say from this point on, we won't do anything. And there is a public trust here about who gets the benefit of what plan, payment plan, tax plan, foreclosure plan, buying plan, that I think we need to address, or that Mr. Sabri's office needs to address at one point. I think the remedy for all of this is the conflict of interest form, that from moving forward, just for the protection of Mr. Sabri and his family, it's just to disclose all of that. And it just seems very simple to me, that just disclose that information so that there's no question about whether or not anything is being hidden or there's any wrongdoing. So that's Again, I just want to thank Mr. Sabri for his time and efforts and for being here.
Thank you very much, Ms. Carnell.
Okay. Is there any further questions? All right. At this time, I think we can go ahead and put this matter to a vote. Mr. Williams, do you have a recommendation for this board? Or is that the recommendation that you put out beforehand?
Thank you, Mr. Chair. I think my recommendation is already out there in terms of what I believe. I don't know that I've seen proven, at least, that the purchases themselves violated the ethics ordinance. I still do, in the words of what a judge gave me about a month ago, I'm concerned about the payment plans and the notices and the going forward with the properties that were purchased by Mr. Sabri's family. I think that is a concern to me. I think I agree with Dr. Carnell that should have been disclosed, and that the perception that may be a difference that is occurring with the family that isn't concerned with, that the other members of the public don't have access to, remains a concern of mine. I leave it to the board to decide whether they consider that to be a violation, a conflict of interest that violates the ordinance. The reality of that is really ultimately the board's. That's really where I come down on this, having gone through everything, read all of this, listened to the tapes, as well as looked at the ordinance again this morning. I mean, I think that's where my concern is.
I think Mr. Hendricks was waiting for some time. Mr. Hendricks?
I'll give it to Ms. Lucille.
Okay, Ms. Basiro?
Thank you. Thank you. I have a couple of questions for Mr. Williams. You've mentioned the possibility of an anonymous complaint being filed, and the only place that I can find that within, I mean, unless you're seeing it somewhere else, but the only place that I can find that within the rules of procedure
Yes.
are under advisory
Yes.
opinions.
Yes.
This is not an advisory opinion that we're ruling on today. So I'm not sure that would be using that as a standard for determining whether the complainant can be anonymous for an ethics violation towards an individual as opposed to an advisory opinion.
Ms. Becerra, could I ask what section you're reading from?
I'm reading from the rules of procedure of the Wayne County Ethics Board.
He may not have that. I'm not sure.
I don't think I have that.
He has the ethics ordinance.
It's I'm reading
Thank
that.
you.
It's under advisory opinions on the last page. It's subsection B.
And just to respond to your question, again, I take this as, literal in a sense. It does state, any public servant may make a written request for an advisory opinion if the public servant is in doubt whether his or her conduct complies with the requirements of the ethics ordinance. And then it says complaints may be made anonymously. I don't know that I have a clear answer as to whether this complaint by Mr. Evans falls into that. I mean, clearly he didn't make a request for an advisory opinion of this board. That is the only area where it says anonymously, but I'm struggling to get to what is a fair resolution of this for the public, and reaching the conclusion that should this board evaluate this complaint in the context of giving the public some confidence that it is serving a function that assures that the public trust is being honored. And that's really the only question that I have. Admittedly, this wasn't a request for an advisory opinion by Mr. Evans for his conduct, but it was a purely a concept that the complaints themselves, or at least contemplate from time to time, an anonymous complaint. Not saying that there's any place for filing an anonymous complaint that is an ethics violation.
And just a follow-up, I have one more question. It seems to me that you're distinguishing between the burden to move forward and the burden of persuasion. So are you suggesting that this issue of the complainant's failure to appear should be weighed in for our failure of the failure to meet his burden of persuasion?
The burden, again, the burden of proof, two components. He puts his complaint on the table, he sends us a letter, he has gone forward. The question of whether he has met the burden of persuasion, given the board's ability to request documentation and seek conduct an independent investigation and analysis as contemplated by the ordinance, that's really at the heart of this. I've said since April I've been struggling with this question. I knew this was going to be a question, perhaps the question. I believe that given the evidence that is in front of the board, there is an ability to assess whether there was an ethical violation one way or the other. But I like token. I do not believe that the county executive has necessarily personally proven that, but he said he could not. And this really comes down to what is the role of this board and whether that independent investigatory power creates a separate platform for this board to evaluate ethical violations. And the ordinance appears to contemplate that the board can do that. It doesn't prohibit it. And I don't know that it is as easy as to say that, well, if the county executive doesn't prove that the county treasurer violated the ordinance, that if there's an ordinance violation, that a violation should be dismissed by this board. I don't believe that.
Thank you.
Yes, Mr. Hendricks.
So, a couple of comments. And
Oh,
then
turn your microphone on, sir.
a couple of comments and then a motion. I guess each of us as members of this board is just going to come to their conclusion in different ways and for different reasons. For me, this is two things that I'm thinking about: the adequacy or the inadequacy of the complaint, and whatever my lawyer's saying, Avery knows I got nothing but respect for him, but if I disagree with him, I'm going to disagree with him. He brings his advice, and I'm going to say, yeah, I like it, or I don't like it, or I agree, I disagree. And I'm going to disagree with him on a few things. Whether the complaint was adequate or not. And Mr. Thomas has argued that just on its face, and in a court of law, if you bring something forward on that technicality, things can get dismissed, kicked out, and so forth. We're not in a court of law, but he's a lawyer, and I think he's kind of bringing that forward as one thing to consider. I happen to think that this complaint was inadequate. I think it was a media-generated, politically motivated complaint. No disrespect to the county executive, because I support him in many different ways. But on the testimony and conversation that we've had at this table, it was strictly based upon a media report. And while, a free press is sort of at the foundation and rooted in what's great about this country and our democracy and so forth and so on, behind a free press are individuals, reporters, people. And I thought that much of the reporting, for me, there were inaccuracies, There were exclusion of facts. And I know sometimes stories get written for reasons to sell papers. Sensationalism, if you will. That's just a human fact. And so if the reason we're here today, and it is because of the reporting of some articles in our daily newspapers, then we need to be examining the accuracy of that information, which has then subsequently led us to ask for all kinds of other information and digging into Mrs. Sabri's past in ways that we never would have if, one, the articles hadn't been written, and if, two, the county executive hadn't done, I think, what he believed was his political and public responsibility. There's a complaint. I need to raise this up and say it needs to be looked at, but then he brings no significant, substantial, supporting information. I think he was just doing his public service as a county executive. I know he's got no axe to grind against Mr. Sabri, but I think he was tossing it into our court and say, you guys figured this out. I'm just going to file a complaint and then I'm going to go back and do my work. To me, that's an inadequate complaint for me. I would never want to be the person, and I've got 50 years of public service here that I bring to this table, and there are others. I know the judge has got me beat, but the rest of you, you might be close, but you don't. If anybody ever brought an anonymous complaint to me besmirching the character of somebody, I wouldn't give it 1 second of consideration. When somebody's career and reputation hangs in the balance and a person drops an anonymous complaint on the table and then walks out the room, and then that person has to go out and hire a lawyer and spend thousands of dollars and have years and decades of their reputation hanging in the balance. And no person on this board should ever want that to happen to them. I've seen it happen, and I've been in a position where I've been able to stand in the gap of somebody who's been accused of something. So, I'm speaking my piece now. I believe that the fact that there was an independent auctioneer, third party, which is the wall between the treasurer's office and the general public doing business, to me that says everything that I need to know. Besides the fact that Mr. Sabri had been in the county treasurer's office for like a minute, trying to get up to speed on just doing his job every day. Third thing, I've never believed that because of my career path and my decision to work in public service should preclude my family from making a living. My decision on my career should not stop my son, my daughter, my wife, my mother, my sisters, my brothers, if they want to go out and do something. I will let them know where I believe there's a conflict of interest and where my involvement has to be arm's length separate on every level. But I don't believe they should ever be denied the opportunity to make a living because of my career path and the work that I do, as long as it's not conflicting and that I don't have my hand in there somehow steering decisions. Final point. A person's reputation matters to me. And if I know of a person, and I've known of a person for years and years or decades, what their work product has been, what their reputation has been, how they've interacted in the public sector, especially if they've got a career in public service, and they've been squeaky clean on all levels for decades, that's going to have an impact on me when somebody brings these mounds of information here that is totally contrary to everything that I know about an individual. And when you've been in the game for 50 years like I have in public service, you get to meet and know a lot of people. And Mr. Sabri is just one of hundreds and hundreds. People sitting around this table fall in that same category. There are folks sitting out in that audience that falls into that category with me. I know who you are and I know what I believe about you. That impacts how I feel about these proceedings and my decision. And so, for all of these reasons, I'm making a motion that we dismiss this complaint. And I'd like to get someone to second it. If we need to discuss it more, I'm happy to have that
Before we
discussion.
get to your complaint.
No, I have a motion on the table,
Before we
Mr.
get to
Chairman.
your motion.
No, you can't. Once you make a motion,
Well, the motion has, first off, the chair
true.
has to accept it, the chair. So
Well, it has to be
you can
seconded.
put your
It wasn't
motion, you can
seconded.
put that you want to make a motion.
Okay, it's been
but we're
moved
not
and
going
seconded,
to.
Mr. Chairman.
I'm not going to entertain that motion
you
at this
can,
time.
what do you mean you're not going
I'm
to
not going to entertain
entertain
that
it?
motion at this time. We're not finished discussing this.
Excuse me, you discuss it after
No,
the
we're not
motion.
going to entertain that motion at this time.
Mr. Chairman,
We're
you're
not gonna do
violating,
that.
you're violating
No,
Robert's
you-
rules,
no,
brother.
no.
I made a motion, she seconded it, you accept that, and then we can have all the discussion in the world.
Seems like
But
you're
you
trying to circumvent the process here, Mr.
The pro-
Hendricks. You were making a comment.
Mr. Judge, would you?
And
would you-
I'm going to make a
would-
motion that we're going to go ahead and second it, and then we're just going to circumvent the process.
No, we're not circumventing
We're
the
not going to
process.
do that. You know, the chair is not going to entertain your motion at this time. Now, I'm not saying that your motion is foreclosed from being entertained at some point, but what I'm saying is the chair is not going to entertain your motion at this time.
The
Now, you
motion
are-
has been made, and it was second.
Mr. Chairman, so I believe I believe you wanted to discuss it, so we can, with that motion and acceptance on the
Exactly.
table, we can discuss it at this point.
Exactly.
Okay, well,
That's the way it
motion
works.
is there. You can,
Yeah.
the motion will be there. I'm not going to entertain it right now to have a vote on this
No, you're not
motion.
calling for it, I'm not asking for that.
You didn't call for the
Yeah,
vote,
Mike,
Mr. Chairman.
what I wanted to just add, though, because I
But excuse
looked at
me,
some
I'd
of
like to get
this.
some recognition for where we are in the process. A motion was made, it was second. I believe what is in order now is that we have all of the discussion and conversation in the world, and then you can decide when you want to call the question, Mr. Chairman. And I would defer to the lawyer here on the procedural question that I have on the table.
Through the chair, Mr. Pickens, I believe that Mr. Hendricks is correct. At this point, under Robert's Rules of Order, it is discussion time now that the motion has been made and seconded. You can discuss the motion. You don't have to call the question on the motion, but I think it is appropriate to discuss the motion now. It's under Robert's Rules of Order.
As the attorney has said that for the board, then I will take that as it may. So then we'll discuss the motion then. So is the motion, as you say, is that the complaint was invalid? Is that the motion? The complaint was invalid because it was not supported?
No, my motion is that the complaint be dismissed. That's my motion.
And the basis?
You've heard my discussion, Mr. Chairman.
Okay,
My
so the
motion is
basis-
that
So the basis was the motion be dismissed because it's invalid, as the way you see it. It was just put out there, and this person did not come and support their motion. The complaint.
Am I on trial here now? You're going to start
Possibly so. If you're going to put it out there,
No,
you're
I'm-
on trial. You put out the motion, talk about your motion.
I
That's what we're
did.
doing.
I stated.
Don't throw it out there. You're
Excuse me.
basically being what the other person has
Excuse
done.
me.
You threw it out there and you're running away.
I
Put
stated
it out
my
there and talk about
reasons.
it.
I stated my reasons, and now I made a motion to dismiss. It's been seconded.
Okay.
Now,
And
you-
that's what we're talking about. We're talking about your motion. That's what we're talking about. And you
Right.
said you wanted, you asked the motion be dismissed, and we're talking as to reasons as you wanted to dismiss. Right? Okay, Ms. Cornell.
Mr. Hendricks started his conversation that there would be different reasons why his colleagues on the board would look at this. And so if we all have our different reasons on how we look at this, there are some things I agree with Mr. Hendricks on. There are a couple that I don't, that the ordinance says indirectly, which would address the third-party issue. And I'm not sure I want to go down this road of whether or not the complaint was valid or not. It's based on the evidence that we have in front of us, because we don't know what's going to happen down the road, whether or not there's going to be another complaint similar to that where the facts are very clear that it is a conflict of interest. I just think that the facts that we have here that were presented to us by Mr. Sabri's office are not a clear-cut, black and white, gray. It's gray. It's too gray. What does substantial mean? What's the timing of the ordinance? There's too many unclear pieces, which is why I suggest just disclose that information, and that will keep you clean. that would be my reason for dismissing. I think we all have different reasons, but I think we may come to, the question is whether or not we all agree to the bottom line of dismissal.
Mr. Pinkins, could I add something?
I think Ms. Buciero, I think she had or someone else had a question.
This is a time for board discussion.
No, I just
So, because right now, what we're doing is discussing the dismissal. So I just want to make sure we stay to that that's what we're discussing. And before you, go ahead, Mr. Thomas.
Well, I didn't want to interrupt you, Mr. Chair, but I think it's been pretty clear in terms of my position from the very beginning. And if there are those that don't know what my position is, I'm happy to restate it. Before the hearing began, my concern was that we were sitting and hearing an issue raised by newspaper reporters, and there was not sufficient information, even in the reports, that gave me ease in proceeding with the hearing where the defendant, for all practical purposes, Mr. Sabri, had the burden not only of defending himself, but of presenting the evidence that was supposed to convince this board that he was guilty of ethical violations. I had a problem with that, and I still do. The other problem that I have is we have rules. This is an ethics board, and ethically we are obligated to follow our own rules. And Rule K, for lack of a better way to describe it, says that the burden of proof, the complainant has the burden of proving the allegations by a preponderance of the evidence. We don't have a plaintiff or complainant in this case. What we got was a letter from the county executive, who I have the utmost respect for. So I in no way want to have anything that I say interpreted as a denigration of the county executive, because it is not meant to be that way. I also would like to commend him for submitting this question to the ethics committee or ethics board, primarily because the public does need to know what happened, if anything, and are they being treated fairly, and is someone else, because of a relationship to the treasurer, being given preferential treatment. There is absolutely nothing on this record, as far as I am concerned, that shows that Mr. Sabri in any way showed preferential treatment to his wife or his son or his son's client. There's absolutely nothing here that supports that. Mr. Sabri was questioned extensively about the relationship between his son and the auction in 2017. He was questioned extensively about his relationship to the companies that his wife has. There have been statements also made. I think everybody here knows that I was a judge, and I was a judge for 26 years on the Recorder's Court bench and also on the Wayne County Circuit bench. There have been statements made that their husband and wife, obviously, they talk about everything, and it's difficult to presume that Mr. Sabri did not give his wife inside information. The reason I pointed out that I was a judge for 26 years is, as a judge, I was obligated not to discuss my cases with anyone, and that included my wife. There were times when she would ask me about cases, and I had to tell her I wasn't going to talk about it, so don't ask me. She, of course, would ask again, steadfastly and to my own detriment. I did not discuss those things that I could not discuss with her. So I cannot sit here and presume without any testimony that says, yes, I discussed all this with her, or yes, I discussed all of this with him, that they had conversations about what she was doing. Wives have their own lives, they have their own occupations and endeavors, and they do not always necessarily discuss them with their husband. The other thing that is of concern to me is that not only did the complainant rely on hearsay, he admitted he had absolutely no personal knowledge of anything that had occurred. There was no investigation made outside of the things that we have done as a board here relative to what might have occurred, other than what you read in the newspaper. I can say from personal experience that all the times that you read something in the newspaper, you may not be getting the whole truth. You might be getting a bias. And I'm not saying that it's fake news, because that's a term that's thrown around too much. I have the utmost respect for the press, and I think they should have the opportunity to present to the public what they see as news. But you can't take out the fact that some reporters have a personal bias, and they write the story from that particular view. Now, much has been made about relationships and ethics and integrity. There is absolutely nothing on this record that indicates Mr. Sabri is not of the highest integrity. There's absolutely nothing. Nothing that shows that he would do anything that would jeopardize the public's interest in the office that he holds, which is a very important office. There were comments that were made that too many people are losing their homes. Too many people are having their homes foreclosed. That's a fact. But the other side of the coin is, without the taxes that are generated by the property, government cannot efficiently run. Government cannot support programs that support all of the citizenry if they don't have the resources to do it. If the taxes are not paid, the only remedy is to foreclose on it. And the people that own the property are given an opportunity to pay the taxes. If they don't pay the taxes, they already know what the ultimate result is going to be. And that is that they are going to lose their home, even though they may have spent their entire life trying to procure this one asset that everyone holds so dear. But the fact remains, taxes are a part of life, and they have to be paid. So I understand the argument that people are losing their homes, but that's not the fault of Mr. Sabri. That fault lies elsewhere. In any event, I don't see anything on this record that indicates that there was a proven conflict of interest on behalf of Mr. Sabri. The only other thing that I can say is that Dr. Carnell seconded the motion prior to my being able to. And that's the end of my statement.
I'm sorry. All right, that's you're the only one that's admitted it.
Okay, all right.
Mr. Chairman? if you
Yes. Mr. Young.
Real quickly, if I may, I agree for the most part with what was said here, but I come to the same conclusion only for a little bit of a different reason. We did have the discussions, and it was raised by Mr. Thomas early on, procedurally, complaint being deficient, Mr. Evans not providing any additional information, and those were valid arguments, and certainly from an attorney and from a court proceeding, those would probably result in 99% of the time the case being dismissed. We're not at that point in these proceedings. Maybe we're quasi-judicial to some extent, but it was a very valid argument. But as we were wrestling through this, if you remember, 2 meetings ago, Dr. Carnell looked at your client and said, I'd like to hear from you. And we seemed to move on from there and started to look at this substantively. Now, whether we should have dealt with it procedurally before or not, we as a board decided, based upon the recommendation or suggestion, we want to hear from you. And so we did. Your client opened himself up and answered the questions, provided documentation. Whether at that point procedurally he should have had the burden to do that, good argument against it. However, that's the process that we did. That's where we're at today. You said earlier in your closing argument, where are we today? Well, where we're at today is we had a lot of information, a lot of proof. We've listened to your client testify. We haven't had anything from the other side, but that's what we have today. And your arguments have been compelling, as I said last time. And real quickly, if I look at this, if you went through and you took the newspaper articles and you sort of put in order what you thought the complaint might be, and you separated it with the different properties. And the first go-around were the 3 properties purchased by Mrs. Sabri in 2011. And you pointed out, and it was very compelling to me, that the very ordinance that enables us to be here today or causes us to be here is the ethics ordinance, and that wasn't enacted until 2012, or a year after this transaction took place. Whether there's any matters that need to be reviewed outside of the ethics ordinance, I haven't thought about it, and it's not for me to be concerned about, but as it relates to the matters that are here today, this ordinance wasn't even law, if you will, at the time that this activity took place. Extremely unfair to take an ordinance, and especially that's punitive in nature and reputationally, as Mr. Hendricks points out, and everybody else, and to apply something in a retrospective manner like that. It's just, there's just something inherently unfair about that to me, and I think to everybody else for that matter. And for those reasons, that aspect of the complaint just has no merit with me factually. I understand the emotional arguments, I understand the other arguments, but at least as to those, it has no to me, no legitimacy at all. The response that there's 71 communities or 67 communities that have a different way of doing things, that just isn't so compelling to me. I mean, the Treasurer's Office adopted rules, and whether those rules are valid or invalid, whether those rules should be altered or changed, whether those rules are even fair or not, is not something that we as an ethics board are going to get into and determine. I've made arguments before. I don't want to get in and start running the various offices in the county. Don't have the jurisdiction to do that. Don't want to do that. So if that is the rule that exists at the time, whether there's a valid reason for it or not, it's the rule. And if it's not right, then change it. So whether that exists or not, I'm going to set that one aside. I'm left with the purchases, or not purchases, but the involvement by Mr. Sabri's son, Adam, and his representation, and whether or not he had attorney-client privilege restrictions, which I totally agree that he has, but aside from that, he didn't purchase these properties, and Mr. Sabri testified he had no knowledge of this happening. Now, as Judge Thomas says, we're left with the record here. So if you have a situation where we have an ordinance that says you don't participate in the purchase of properties, and you don't want your family to do it, and it defines who that is, but again, if you don't know who, you don't even know that activity is going on, how do you hold somebody to some sort of violation of a standard and an ethical ordinance on something that you don't control, you have no knowledge of, and you certainly would not be in any human way have the ability to prevent it or to stop it? I think what the purpose behind the ordinance in that regard is they didn't want public officials creating a straw man situation, getting their son or daughter or cousin or somebody to go out and buy property where there's a collusion going on and the like. absolutely no evidence of that we're left with, and I believe Mr. Sabri's testimony in that regard, because we questioned him pretty hard on that. I did too. And so I take him at his word, and with that fact being undisputed as such, then those properties, or at least that effort by Adam Sabri, is off the table. So although I agree that the complaint is deficient and the like, I think because we ventured down the road of getting to the substantive part of this and the facts, I think that the record leaves us from a factual standpoint of making a determination, and at least in my mind, the only determination that there's no evidence in here that would suggest or any way support any action by Mr. Sabri that would be tantamount to a violation of this ordinance. So although I agree with what was said regarding the complaints and the like, I think factually, I think that's where we're at. So if Dr. Carnell had not seconded the motion, and I could have jumped in front of Judge Thomas, I would have seconded the motion also, but for different reasons. So thank you, Mr. Chairman.
Right, let me just make a quick comment, and then I'm going to turn it over to you, Ms. Becerra. And I'm going to agree with my colleagues to an extent, definitely with Mr. Young. I'm going to disagree to a certain extent, just because I know that complaint had been filed prior against, as I mentioned, former Sheriff Napoleon, and there was no one here. That was raised that there was no complainant here. The board at that time didn't even consider that. And again, there was no one here. Mr. Napoleon's reputation was put into question. It was all over the papers and the news. His reputation, again, was put into question. But he came and he appeared and he defended likewise. And he didn't argue about all that. He didn't say all my reputation. He understood, I think, which public officials do know, that I think that's part and parcel of the position. You are a public official and you are held to a higher standard. That's why some people decide not to go into public office, because of that scrutiny. And as the saying goes, that with much is given, much is expected. I'm going to disagree with this, with that part of it, and also under our advisory opinion. Well, here, let me just say this too. I know some things were mentioned about, because I agree with the fact that the properties that were purchased, it seems like before the ethics ordinance was in place, that we don't look back, and there's no retroactive ex post facto laws, as you mentioned. My concern is the properties after that that were owned by the companies owned by Mr. Sabri's son. The fact that we were not given any forfeiture notices. I understand wholeheartedly that, yes, taxes have to be paid, and people losing their homes for non-payment of taxes, yes, we understand as a part of it. Government needs taxes to build roads, pay for police and whatnot. However, those taxes need to be paid by everyone. If there's an issue with a family member of a treasurer who's able to rack up $50,000 in unpaid taxes, that's tax money that also should be paid to the county, so that we can use that money to build roads and do what we need to do. If everyone else is losing their homes from paying taxes, my concern is, why wasn't these properties foreclosed, or where were the payment plans? If they entered payment plans, which was asked, where were the payment plans? So it would show that they've been treated like everyone else. Other people given payment plans, they should have been given payment plans. And if they were, show us that. If they were being foreclosed upon like other people, show us those forfeiture notices. That would have shown me that they are being treated like the public. There's no difference here. There's no discrepancy. There's no sort of favoritism placed on his family. And when we don't get that, and we're told that we're just not going to get that, then it makes me think it doesn't exist and the public is not being treated as his family was. That's my concern. With respect to, I see that there, with the fact that he did mention that he was still a member of this U.S. Development Corporation. I see information even in 2014 where he signed as the manager, member, agent, signing documents. He testified that he signed documents. He paid the bills at the last hearing. He did say that he paid the bills. He said he was a limited member, but he advised the corporation that. This corporation has purchased properties in that. Again, a disclosure. I agree with Ms. Carnell that that could have just been a simple disclosure that I am a part of this company as a limited member, a simple disclosure form that we all are required to file. I am a member of this company, a limited member. this is what I do. Other than that, there's no conflict of interest or what have you. Disclosure notice. Other than that, I was looking at the here that I think Ms. Carnell raised. Under advisory opinions, it talks about complaints may be made anonymously. However, my question, though, to Mr. Williams is that an advisory opinion doesn't come by way of complaint. In my understanding, if I look at the next section, the Ethics Board shall promptly forward all requests for an advisory opinion to all Ethics Board members. So an advisory opinion would not come by way of a complaint. So it seems like that subcategory is out of place. When it says complaints may be made anonymously, it seems like that should be made in a bigger body. And again, prior boards have looked at complaints made by people not being here. It seems like that's what happened under Mr. Napoleon. And I'm sure he would probably feel the same way, that he had to come, his reputation was placed in question, and it might have been politically motivated. It was right after the mayor's election, and these things came up. An election that he did not win, but it came up. Again, he came, he defended, he was here, his reputation was placed in question, but he did do so. So that is my disagreement. I agree in part with respect to what Mr. Young had raised. I do agree that there should have been disclosures. I agree that properties purchased before the ethics ordinance was in place wouldn't fall under the ethics ordinance. And with that, I'm going to pass it over to Mr. Becerra.
Thank you. I wanted to thank you guys, Mr. Thomas, Mr. Sabri, for being here and for cooperating to the extent that you did, because you certainly didn't have to. There was nothing obligating you to do so. In the beginning, you had raised some issues regarding the complaint, and Mr. Hendricks has raised those as well. I disagree. I think the complaint was sufficient, but because it didn't include any specific facts, the burden to proceed was met by the complaint, but I think the burden to persuade this board was not met by the complainant. Through this process, we had lots of questions for you, which you answered to the best of your ability, and I thank you for that. And I think, with all of this being motivated by these news articles, I think we learned through this process that the facts that were presented from you didn't always match what was said in the news articles, which I think was to your benefit, to set the record straight for the public as well. So I thank you for that as well. I think the due process issue that you bring up, which is, in my view, the recognized process for someone who's accused to confront their accuser, that was not present here, and that is my biggest issue through this whole proceeding. And I will be voting to dismiss this complaint as well.
Mr. Pinkins, I had asked to respond to Ms. Carnell's
Yes.
comments
Yes,
before.
go right
Might I
ahead.
respond?
Yes.
Ms. Carnell, I would like you to know as I'm getting a little bit older, I try not to do that many jury trials, but I did one as recently as probably 10 or 11 months ago. In a lot of criminal cases, judges will not have any objection to the lawyers, the prosecutor and the defense counsel, talking to jurors about the case. And let me tell you, you want to talk about an educational experience. You could talk to 3 or 4 of the jurors out of the 12 members that actually sat in judgment of a case and found guilt or found innocent. They'll give you a different reason as to why they ruled the way they did. But they voted to convict, or they voted to acquit. So the fact that one or more members of the board may not support all of the reasons that another member is voting to dismiss, that's no different than any time any group of people sit in judgment of another. That's all I wanted to say.
Mr. Chairman, may I respond to something?
If you like.
I just wanted to say that I'm going to have to leave soon after you go take a vote.
You know what? If you like to leave now, it's up to you. I understand we're past the 10:30 mark.
Yeah,
If you would like to, we will excuse
We're so
you.
close to the end, I might as well stay. But at this time, I'm going to leave right away. So I want to just thank the board members for their participation.
And thank you for being here.
I know that you all are not getting paid for this, and volunteers, and thank you for your participation and your consideration.
Thank you, sir. Thank you for being here. Ms. Cornell.
Mr. Thomas, just for the record, I was in agreement with Mr. Hendricks that all of us do have different opinions about why we think a certain issue should be either dismissed or not dismissed. I think that we're at the table of dismissal. So I'm in agreement. I wasn't in disagreement to that position.
Thank you very much, ma'am.
Okay, all right, well, at this point, I think we have your motion to vote on.
Just one
Oh, I'm
last
sorry,
point,
Mr.
Mr.
Hendricks.
Chairman. I think that through all of this, and this was a very in-depth, detailed, and extended proceeding. I think for me, what I've learned in all of this is the shortcomings that this ethics ordinance has, and that there's some fine-tuning with all of the good intent that was surrounded by this ordinance being passed by the commission. I think we would be duty-bound as this board to take from this and some of the past cases that have recently come and do the T's and the I's and the fine-tuning and send it over as a set of recommendations to the commission so that where we ran into questions or conflicts or insufficient direction from the ordinance, maybe what can come out of this is a better ordinance.
All right, with that said, I think we have a motion on the floor. I think it's been seconded. Let's, to all in favor, say aye.
Aye.
All opposed? Aye. I think the ayes have it. Mr. Brown, do you want to take a vote tally? I'm sorry, nay. I'm sorry, I think I said aye. Nay, so, well, nay.
Motion passes to dismiss.
Okay, all right, so we'll move on to our next order of business under item D of our agenda. Again, thank you, gentlemen, for being here. Thank you for the public. We're moving on to item D, letter D, which is new business. Is there any new business before this board at this time?
Chairman, we have no new business.
Okay. We're moving on to item E of the agenda, which is such other matters as may be properly submitted before this board. Any other matters before this board at this time?
Scheduling of the next meeting.
Mr. Chairman, I'd just like to thank the chair for the effort in these proceedings, difficult process, and got contentious a little bit with the audience and the like, and I do appreciate your effort and your ability. And also, I want to thank Mr. Williams. I had a high regard for him before these proceedings started. I have a higher regard for him now, so I do appreciate his effort in this, and I just wanted to say that, because these are difficult times.
Thank you for those words. And,
Ditto.
Thank you for those words.
I concur.
All right, thank you all. Thank you all for those words. We're going to move on to item F on our agenda, which is public comments at this time.
I have a,
No,
I'm sorry.
we'd like to go back.
We
We have to go backward, too.
Okay.
For scheduling for the next meeting, let's see, secure. In August, only one Wednesday is available. That's the 21st, the 7th, the 14th, and the 28th are all booked. There's rooms booked, for committee meetings are being booked. And then, that's the only Wednesday. I know a couple before the meeting, a couple of board members have said they're not available on Wednesday, so on that Wednesday, the 21st. And then September, the available dates are the 4th and the 18th.
If we want to follow tradition, I think last summer, if the board members are in agreement, I think last summer we took the month of August off, if I'm not correct in saying that.
I think you're correct.
So if the board members are in agreement, I know we've done do some traveling. That's the last month of the summer. So if the board members are in agreement, we can
At the
entertain.
21st, Mr. Chairman?
Actually, the 21st of August, I believe, is that open?
Is that the one?
That is the one that's open, yes.
Is that the one you were talking about canceling, Mr. Chair?
If the board is in agreement, I will consider canceling that meeting. If the board wants to meet, if I know people have vacations coming up, traveling and whatnot, I will entertain that. If not, then if the 21st works for everyone.
There are no pending matters.
Through the chair, there are currently no other pending matters before the board. So nothing has been submitted as of this morning. So
If I may, Mr. Chair?
Yes.
I would move that the board not meet on August the 21st
Is there a
of
second?
2019.
Is there a second?
Second.
Is there all in favor?
Or any day.
All in favor?
Aye.
So move. All right, let's look at September then while we're at it.
18.
Okay, the two available Wednesdays as of right now are the 4th, which is the first Wednesday, the 18th, which is the third Wednesday.
I'm available the 18th.
As am I.
That's August 18th? really?
Or,
September.
September
I'm sorry,
18th, yes.
September 18th, okay. That works for me. That works.
Okay.
Okay. That works for the chair. Okay.
So the next meeting scheduled for
August 18th.
August 18th, provided we have items.
September 18th.
September, sorry.
September 18th. yeah.
Sorry. So on September 18th, 9 a.m. here in this room.
Unless the commission preempts us.
Hope not.
And Joe, I wanted to thank you for providing us with all the information and all the hard work that you did.
And
during the course of this hearing.
Darcel too. Darcel
Thank
too.
you.
Yes.
Thank
And
you.
Darcel.
And
Thank you for what you- Darcel, thank you so much. Mr. Williams, thank you so much for all of that. All right, moving on to the next item of business. At this time, we're moving on to item number F, which is public comments. Are there any public comments at this time before the board?
We received no written public comments prior. We do have 4 cards here.
Okay, we'll move forward. What's the first person? on
First
the
card, Elena Harada. I'm sorry if I mispronounced.
Yeah, she had.
Next person.
Then the next person, we'll just put her at the back of the list. Next person is Bill Wiley Kellerman.
Mr. Kellerman, how are you? If you want to come to the mic, sir, if you have some I'm sorry, Ms. Harada seemed like is here. If you want to come to the mic, either or.
Thank you very much. I just want to say that as a taxpayer and a homeowner in Detroit, and as a person who has struggled, like all Detroiters, to pay my bills with incredibly predatory car insurance, for us to be able to keep our homes, for us to be able to keep our water on, is a struggle every single day. It is very disheartening to me to see someone be able to own so many homes, to begin with. In the position of treasurer, whether or not there was an ordinance, what was in the ordinance, the fact that the treasurer, who is responsible for collecting taxes, has the appearance of such a hookup and has the appearance of such support for the hookup is very disheartening to me. I just want to say that whatever the law is and whatever the lawyers can be able to manage to do is a very different thing than what the reality of our lives is and what the reality of Detroit is under the post-bankruptcy. We have suffered so much, and to watch people be able to acquire and acquire and acquire while others lose and lose and lose, I just want to say thank you very much. Thank you.
Thank you for those words.
Next is Mr. Bill Wiley Kellerman.
Yes,
Good morning, sir.
thank you. Bill Wiley Kellerman. I'm a retired United Methodist pastor, most recently from St. Peter's Episcopal Church in Corktown, and a resident of Southwest Detroit. A little frustrating to be making public comment after the fact. That seemed to be preempted, and Mr. Sabri is gone. Nonetheless, the context in which all of this is happening is tax foreclosures, city and county, in the city of Detroit, along with other mechanisms like water shutoffs, mortgage foreclosures, school closings, that are extracting people's legacy and assets that they've built up in this city and expelling them from neighborhoods, destroying neighborhoods. For the treasurer to benefit from that extraction is very problematic. And especially for these houses that the LLC or his wife owned, not to be notified of tax arrearages in ways that other people are and lose their homes, the homes they live in, is also ethically problematic. We need officials to be, and that includes boards and commissions, to be public servants, not self-servants. And that's the fundamental issue of ethics. Thank you.
Thank you, sir. Next person.
Ms. Beverly Kendall Walker.
Yes, Ms. Walker.
We have somebody else with a card.
Okay.
Yeah, there is.
Come forward.
Thank you.
Good morning. Beverly Kendall Walker.
Morning, Ms. Walker.
Representing the community at large, if you would, the public trust. To say the least, that this has been a stunning position to have taken based on the information that you have received, and to say that the information that was provided by way of the articles in the News and the Free Press and Metro Times, which the reporters did an excellent job. They FOIA is in Freedom of Information Act and got supporting documentation of things. I don't understand how it was or is that you arrived at that conclusion, absent of your chairperson. I think this requires furthering beyond this ethics board, as an attorney general should look into it, because there's been some definite perjury done here. As a county employee, which Mr. Shabri is, every March the 15th, we are required to file a conflict of interest statement. If he filed it and said he had no conflict, of no opportunity to profit off of anything relating to the county, he perjured himself. That is not your ethics ordinance. This is something that county employees have to do every year without fail since 2011. Then the other thing is to say that Mr. Botovich suspended, eliminated, or canceled his policy that said he didn't want the very appearance of somebody profiting from the treasurer's office or contractors in the tax process is in error. I talked to him personally in the last couple of months, and he was appalled to hear that had been stated by Mr. Shippery. So, and the reporter additionally interviewed Mr. Botovich, and he stated that. So, you guys made your decision, that's well and good. It needs to go to the Attorney General or to the governor, because the public trust has seriously been eroded here. Seriously. Thank you.
Okay, ma'am. Thank you for those words. The next person.
There's a no name given, but it's Hope for America Incorporated, but there's no person's name on it. Can we get your names, your spelling, please?
Tamika Gaines.
Can we spell that, please?
Tamika Gaines, Gaines.
Thank you.
What I would like to say is, first of all, you guys have a very difficult position to be in. Being neutral is very difficult. However, the evidence that was presented before you gave you the conclusion in which you have. I speak because Hope for America, which I am the executive director and founder of, helps young people get involved in skilled trades. Believe it or not, Mr. Eric Sabri, humble beginnings, started in skilled trades. He is very active in our community, and he is a stand-up person. The reason I know that is because I represent the community as well. It's just that I haven't ran against him in any election, so therefore I have no vested interest in making him look bad or make my position look great. I'm just here as a humble servant of Hartford Memorial Baptist Church, as where I serve as a deacon. And Mr. Sabri comes and he informs us, he sends a staff to inform us of foreclosure dangers and such as those. And just to show the reverence that I have for Mr. Sabri is I was terminated from my position at my job, and I fell behind in my taxes. Mr. Sabri is actually on my advisory board. Do you know I would not go to him and say, oh, help me. I did not want him to know that I was in impending danger of losing my home because I fell behind, because I wanted to never put him in a position of such. So I, just out of respect, never wanted the sense of disappointment, because he's such a stand-up guy, to even share my dilemma where I needed to work out some things. So I did what I needed to do to sustain my household, because I haven't worked in a year and a half, but my taxes are paid because we make those concessions that we need to make our lives sustainable. Now, if you don't have an income and you still find it necessary to maintain your household, that right there, and you don't run to a resource that you could call, but you don't want to put them in impeding danger of being unethical or any of that. So I stand right before you and I say that you've made the right decision, because none of this is political for me. Political interests are very strong in this room, and I will state that. Tamika Gaines said that. The politics are thick, and nobody can hold Eric Sabree accountable for their misfortune of losing their homes. Losing your home is a devastating experience. I'm aware of that. I have lost a home before. I just haven't lost my present home. And it wasn't Eric Sabree's fault that I lost my home. It was a financial hardship. That happens. And I know that he could not support any neighborhood, any community, any Wayne County initiatives in his office if we don't pay our taxes. That could not happen. So taxes are necessary. Even in the Bible itself, pay Caesar what Caesar is due. Unfortunately, he has the unliked role of Caesar in this situation. He must do his job. He is doing his job, and he does his job with integrity. I stand before you in thanks. Once again, Tamika Gaines.
Thank you for those words, ma'am. I think we have one other person at this time.
Yes, Mr. Joshua Van Berkom.
Yes, Mr. Van Berkom. And I want to thank you all for being patient and staying to the end to give your public comments. We really appreciate the input.
Thanks, everyone. You kind of feel like family. It's been a few months now, but I probably won't be back here next month. I want to thank you guys, because it's been obvious to me that there was a lot of struggle here with, you've got an apex employee of the county delivering something that the bylaws sort of don't really allow you guys to address in an appropriate way. And I really appreciate the fact that you guys dove into this and took this on through much discomfort for everyone. So I want to thank you guys for that, and probably also welcome you guys to the club of people who know way too much about tax foreclosure. So your knowledge had really came along as the process went, and I appreciate that, because it's not something that comes very naturally. One thing that it doesn't sit quite right with me is the star witness. I heard the name maybe a dozen times, Mr. Spalding. He's a pretty well-respected individual that hosts county auctions for, I don't know if it's 60 or 70 counties throughout Michigan. And I thought the case that he made in some ways was valid and fair when he was here in May. What bothers me is I would imagine that by getting Wayne County as a client, he would double his business. So I think if a star witness were to ever say, obtain Wayne County's business during Eric Sabree's tenure, that would ethically bother me a little bit, and I hope that that's something that wouldn't have to be revisited here, lest we open some wounds that should have healed. So that's all I have to say. Thank you.
Thank you for those words, sir. Thank you. Is there any other comments at this time? All right, with that said, I'm going to move on to item G of our agenda, which is adjournment. Is there a motion to adjourn? Is there a second? All in favor? Aye. We are adjourned. Thank you so much, everyone. Thank you.
Thank you.
Thank you.